Second part of Chapter 17, we look at the agent's authority, liability of the principal and agent, as well as termination of the agency relationship. An agent has authority when they have either actual or apparent authority. A principal is liable for the acts entered into by the agent when they have one of these types of authority. Actual authority is either express, orally or written, or implied, either from the conduct of the parties or as part of the express authority. Apparent authority means there is no actual authority, and you get it through a number of different ways. One we talked about last week was agency by estoppel, and that's where the principal leads the third party to believe the agent has authority to do something they don't actually have, or that somebody is their agent when they are not actually the agent. We also talked about ratification, where the authority is given after the fact, and in some situations we talked about how an agency could be created by an emergency. As I mentioned, express authority is either oral or written. There's the equal dignity rule, which says that if a contract needs to be in writing, the agency to procure or enter into that contract needs to be writing too. Some exceptions would be an executive officer who is acting for a corporation couldn't possibly have everything that they need to do expressed in writing or orally. And in a case where an agent acts in the principal's presence, there's authority. Power of attorney would be an example of express authority. It's in writing, usually notarized. It could be to do a specific act or generally for a business or an individual, and it terminates on a death of the principal or incapacity. Implied authority might be inferred from custom or the agent's position. The test is whether the agent reasonably believed that he or she had authority to do the act. We mentioned that apparent authority is when the principal causes a third party, not the agent, to believe that the agent has authority, either by word or act, causes that third party to reasonably believe, and it could be as a result of a principal's pattern of conduct over a period of time. The idea is that the principal is just stopped from getting out of what the agent did because the third party changes their legal position in reliance on the principal's representation. Ratification we talked about last week. This week here are the specific requirements. The agent does act for the principal. The principal learns of what the agent did without authority and affirms the entire deal, including the part that was not authorized, and the principal does this before the third party has it withdrawn. The principal and the third party must have legal capacity to contract, and the principal needs to know all the material facts involved in the transaction to ratify something. In other words, you can't ratify something you don't know about. Principals can be classified as disclosed, partially disclosed, or undisclosed. A partially disclosed principal would be when the third party knows they're dealing with an agent, but they don't know specifically who that principal is that they represent. An undisclosed principal, the third party doesn't know that there is an agent. They don't know because they don't know of any principal and therefore don't know who that principal would be. Another way of saying this would be that the third party only knows about the person they're dealing directly with and is unaware that that person represents a principal. If an agent's act is authorized, then the agent is not liable and the principal is. There are situations where the principal identity or the fact that there even is a principal is concealed, But as long as the agent's acting with authority, the principal is usually liable unless there's some exclusion of liability or contracts for negotiable instruments, or the agent's performance is personal, or the third party wouldn't have even contracted if they'd known who the true principal is. An unauthorized act is when the agent acts outside their express, implied, or apparent authority. If they have no authority, the principal isn't liable and the agent is personally liable. Generally, an agent is liable to a third party for their own torts, and the principal may also have liability for that agent's torts if they result from something that the principal directed, the principal is involved in the tortious conduct, or the principal should have known that the agent was engaging in the tortious conduct. A principal can have also have liability for agents' misrepresentation. They can have liability for an agent's negligence if the agent's negligence was in the capacity of a employee under the doctrine of respondeat superior. They're vicariously liable for the employee's negligence if it's committed within the agent's course and scope of employment. Even if it's a detour, in other words, it's while on the job but slightly off the job. For example, a truck driver who takes a detour, that would still be considered part of their job. But if it's a frolic, if it's not related to their job, if the truck driver were to take the truck on his or her own personal time and do something completely unrelated to their employment, that would be a frolic. The big deal is a detour, principal is still liable. A frolic, the principal isn't. Typically, traveling to and from work is not within the scope of employment. However, there may be employees who travel as part of their employment or are traveling somewhere as directed by their employer. A principal is liable for intentional torts that are committed within the scope of employment. Employer is also liable for the employee's acts which the employer knew or should have known the employee had a propensity to commit. Generally, an employer is not liable for the acts of an independent contractor. So the first step would be determine whether the person is an employee or independent contractor. However, there are exceptions where if you would be held strictly liable, you're unable to delegate or independently contract for that. Example would be unusually hazardous activities, blowing things up, volatile chemicals, poison gas. Generally, agents are liable for their own crimes. The principal isn't unless the principal directed the crime, participated in it somehow, and some states have statutes that make the principal liable for agents' violation of regulations. An agency can be terminated by the act of the parties. Examples would be, it's for a set time period, the purpose is achieved, there's a condition or event that occurs that terminates the agency relationship. Both the principal and agent agree, or one or the other party leaves the agency. However, terminating the agent may result in an action for a wrongful termination, or it could be terminated by operation of law, death or insanity of either the principal or the agent, impossibility, whatever the subject matter was, agents like selling a house that burns down, circumstances change, the house gets sold to someone else, it's still there, but circumstances have changed. Bankruptcy terminates agency relationships, as well as war. It would be difficult to do an agency in a different country when that's in a combat situation.